Okay. From the daily cause list, under heading for final disposal, item 2, fix at 215, WPL 2847 of 2024. मेंशन चले आउट ऑफ लिस्ट है बीए कॉलेज से
Where is the petitioner? The learned counsel of the parties are present in order to give them a chance. Suppose this is on seventeenth.
From the supplementary list under heading for orders, item 1, first appeal 162 of 2025.
Nobody appears on behalf of the applicant. Post on 17th August.
From the daily list under heading for final disposal, item 1, first appeal 154 of 2023.
I have taken instructions because they had sent me a soft copy of the Vakalatnama, but I have told them that you come down and execute the Vakalatnama, only then I'll be able to appear on behalf of respondent number 3 and 5. They're supposed to come down today. Because the notice which was served upon them, Lords, I have inspected the records also. Lords, the notice which was served upon them, but pursuant to an order passed by this honorable court, Lords, to the police. In that, Lords, they have indicated that it is Baby Kumari Urf such and such. However, Lords,
ऐसे उर्फ तो रिकॉर्ड पे नहीं है ना?
हाँ, that is why
तेरा उर्फ का क्या मतलब?
That is why Lords, I have told them to come down. I will verify and pursuant to that, you put in your signatures as you had put in before the learned trial court. Then only I'll try. They are supposed to come down.
Trial court का तो कुछ मैच ही नहीं कर रहा.
Dolly Singh का affidavit है. Dolly Singh has given. Dolly Kumari ka W is
The learning council for the respondents. Seek adjournment. Post on 17.
Actually, in the meanwhile, I was requesting that I have the copy of the entire LCR. On last occasion, Lordship has indicated that translated copy of the impugned judgment has been prepared in the instant appeal. Lordship, that copy will be provided.
I'm not supposed to give you copy. What do you mean?
So
I've
we will-
done it
we will- we will
for
apply for
myself.
the-
No.
So
Why
that
should I?
Lordship, so it would be easier for us to
No.
refer to the
I'm not here to make your life easy. Why should I?
Lordship. We will place the judgment in Hindi. Lordship will go through the English
We
version.
have got it translated so that it is easy for me. It is not to be given to you. There is a reason for that. It's not that I will not share anything whatever I have done. But there can be mismatch, there can be error. Then tomorrow you will say the court has forwarded this copy to me, so
No,
this
that,
is correct.
that will be not.
You will.
But only to that extent that the Lordship will go through the
Because
judgment.
I have not checked it. It is by and large
Very
they
well.
have given a translated
And
copy.
we
to
will
me
not
because I got
place
it
the
translated.
Hindi version so that it may verify that by your Lordship. And we will not submit the short notes of argument by the next date. We will not submit by the next.
नेक्स्ट डेट तो खाली आपको डेट पर डेट ही चाहिए ना आपको कितना
We
साल का
are-
डेट देते खाली इतना बता दो
We are ready with the matter. Lordship.
You are not ready. You are where is your notes? If you are ready,
jointly with 2 weeks time maybe given.
No, just
by
17
next
not
date,
jointly I can give you 20 years time. What
No,
is the
no.
big problem?
It is not a very big issue involved in this matter. Lordship. We will
But still you
submit the-
can't prepare your notes.
we will submit the notes of argument Lordship, by next.
By the next date, because I'll also furnish my written summary.
You would do nothing. I can see it. Right. Today you got some message, a WhatsApp copy of the wakalat. I
Last-
just told you
the
this.
last-
This happened. What was the last date?
Last
week
Monday.
only.
Last Monday it was.
कोई इंटरेस्ट नहीं आप लोगों को बस अभी बहस करने में तो हमको क्यों इंटरेस्ट ये खाली बात अभी तो इनका वकालतनामा एक्सेप्ट होगा कि नहीं होगा देयर इज अ
Does it
$1
fall from your leadership side that it is on my satisfaction, Milord, that wakalatnama, whether I'll accept it or not?
सो अभी तो
So,
आप
like, you know,
वकालतनामा का फोटोकॉपी देके तो बता दिया होगा ना यू विल एक्सेप्ट इट और यू विल नॉट
Therefore, Milord, I've called them. One person stays in Tati Silva, another person stays somewhere in Booty Mode. So I've called both of them. I've called them to my office. Milord, only then will I accept the wakalatnama.
कुछ भी एक एलियस नेम लगा के आप लोग फाइल कर देंगे तो यहाँ फर्स्ट अप्रैल में तो नहीं होगा
That is why, Milord.
I will ask you to file a suit to get a declaration that you are one and the same. So you just wait and see what I do. Yes, that is the only way. कोई भी पोस्टर आके एक एलियस नेम के साथ खड़ा हो कैसे हो?
I was this person. They were the plaintiffs, Milord. I was not.
They are illiterate people.
No.
They are not illiterate people. 10th का certificate तो होगा. That is the only thing.
Concerning Milord, it is a partition suit, Milord, perhaps that is why घर के नाम से उनको party बना दिया गया. They also allowed it to continue for the London trial. That should not happen. Relatives, that is why वो घर के नाम से बना दिया गया. They should not have allowed it to continue. They should have.
अभी तो आप आइए फाइल करिएगा for acceptance of वकालतनामा. He will respond thereafter. आपको क्या लगता है? It will take quite some time. आपको 17 तारीख का डेट दी है आपको दो करना है ये फाइल मेरे पास मत भिजवाया करिए क्योंकि अभी 6 महीना तक ये केस रेडी नहीं होना प्लीज डोंट सेंड दिस फाइल टू मी मेरे को तैयार होने में टाइम इट्स अ वेस्ट नो फाइल आता है फाइल पढ़िए सुबह मैसेज आता है आपको भी जमा होता है मैसेज आता है isn't it when did you text रात को
email हम कल बात करेंगे.
रात को मेल की my office is available to you throughout the night.
I should have.
याद रखिएगा अननेसेसरी नहीं भेजने का है, ठीक है? सुन रहे हैं?
Yes, yes.
नहीं भेजिएगा,
जी.
don't say.
Under heading for orders, item 3, first appeal 79 of 2022. तो 15 के लिए फिक्स था, कॉल हो गया, उसमें एग्जाम नहीं होगा.
What is it for?
Leadership in this respond number 1 is right. So they have filed a substitution. One zero one five four.
What are the name of the legal news?
Leadership is mentioned in para 4. There it was.
He died during the pendency of this
Yes,
appeal.
yes. Yes, died. 14.
Do you have any objection to this?
Only my formal objects, because we have served them the copy of, because we have filed an informatory application informing about the death of this particular respondent. That was filed on 1/4/2026. There is another interlocutory application that we have.
They say they have the power of attorney also. Have they deposited the power?
No. I have the power of attorney because all the heirs of the deceased respondents have executed a power of attorney in favor
So
of.
you have submitted the power of attorney.
We don't have the original copy of.
You have to, otherwise your power of
We have
attorney is of no
informed
consequence.
the client that we need the original copy of the power.
The learned counsel for the respondent submits that he is here to receive the original copy of the power of attorney. आपको फ्रेश वकालतनामा भी फाइल करना है. Counsel for the appellant is absent. Who's on? कब चाहिए आपको?
Because your ladyship, there is another appeal arising of this particular award. That is arising out of same award. In that particular appeal, we have challenged this award.
Okay. What is the date?
Date is 17th of this month.
उसका first appeal का number?
हाँ, उसका filing number
Filing number है.
हाँ, क्योंकि उसमें
number नहीं पता.
क्योंकि उसमें
Defect remove करने के लिए.
हाँ, बस उसमें एक limitation application फाइल करनी है.
Who's this case on 17?
इसमें एक IF करके सब कुछ.
क्या चीज़?
serial item number 79.
यही है ना?
हाँ, ये
तो अभी इनके पास power of attorney नहीं आया.
अच्छा. Substitution कब से मिला?
अभी लोग reply भी नहीं पाई. They have some objection delay.
only formal objection. इतने ही अलग.
तो आप बोल भी सकते हैं.
इसका entire non-appearance is valid. IA number 10154 of 26 has been filed for substitution of respondent number 1, namely Abhay Kumar Rao, who is said to have expired on 14/2026. The names of legal heirs and successors have been mentioned in paragraph 4 of the interlocutory application. A prayer has also been made for setting aside abatement and condonation of DD of 155 days. The learned counsel for the appellant has submitted that the respondents had filed IA number 4558 of 26 under order 22/10A of CPC informing this court about the death of respondent number 1, and the said application was provided to the counsel for the appellant on 1/4/2026. And thereaafter necessary steps was taken. Appellant number 1 is a senior citizen of above 65 years who is suffering from various ailments, and ultimately he came and filed the interlocutory application. The learned counsel for the respondents has opposed the prayer by submitting that the delay is not properly explained. After hearing the learned counsel for the parties and upon going through the IA number 10154 of 2026, this court is satisfied with the cause shown and it was respondents who had filed their IA informing this court about death of the respondent number 1. The abatement in connection with respondent number 1 is set aside after condoning delay of 155 days in filing the substitution petition. The counsel for the appellant is directed to delete the name of respondent number 1 from the cause title and insert the names of his legal heirs and successors in red ink during the course of the day. The learned counsel for the respondents has submitted that the power of attorney has been executed in favor of
Aditya Shroff.
Aditya
Shroff is the son of the deceased appellant.
in the name of one of the
One of the
sons of respondent number 1. A photocopy of the power of attorney has been enclosed with the interlocutory application, but they are yet to receive the original to submit it before the learning will start in. An appropriate wakalatnama will also be filed. For that, they pay for it.
105 of the IA petition, the respondent number 2, even the deceased is one of the legal heirs of the deceased respondent number 1 is already on record as a respondent number 2.
So after the learning counsel for the appellant has also submitted that respondent number 2,
Namely Kiran Devi
Shroff,
who is one of the legal heirs of the deceased
who is
respondent.
one of the legal heirs of deceased respondent, is already on record as respondent number 2. So far as other persons are concerned, we shall add them in writing.
Yes.
I need to allow him. You are seeking time and posting it on 17th August. Post on 17th.
17th of August.
Is it a corrected case?
I beg your pardon, Lordship. These two cases, the other case in that particular application is 81 of 2017. Although parties are same, means we are the appellate in that particular case.
Okay.
So it is not arising out of the same. Means the same.
So they are not arising out of the same.
No, I beg your pardon.
Yeah, I'm just posting it on 17th. I'm not tagging with that.
दोनों आइए
एक ही आई है, एक दूसरा वाला आइए
Informatory था.
इंफॉर्मेटिव को क्लोज कर दीजिए. इसका रिकॉर्ड आ गया है.
इसका रिकॉर्ड देख नहीं
आया
yes
है
yes
कि नहीं आया?
yes
रिकॉर्ड आ गया. पेन ड्राइव में ले लीजिए, आपको देखते रहिए. You also take it.
item 4 FA 162 of 2022
This is for the appellant.
इसमें जो नोटिस इशू हुआ था सब्स्टिट्यूशन में इसमें 3.2 and 3 respondent number 3.2 and 3.3 को बोलते हैं item is transition.
Transit.
इसमें हमको इंस्ट्रक्शन है
On behalf of legal heirs of respondent 3. Mr. नाम बताइए. Mr. Manish Kumar advocate submits that he has received instructions to appear on behalf of all the legal heirs of deceased respondent number 3. He undertakes to file wakalatnama within a week. Within a week.
IA is still pending substitution petition. This may be allowed, any date may be fixed for final
Avi
hearing.
within the wakalatnama and suppose this case on next Monday. Friday तक हो जाएगा Friday.
Yes.
Lord, I'm appealing on behalf of respondent number 10.
Respondent number 10, you will hear it.
Item 5, first appeal 132 for 2023.
The sister was made a party this morning. It's IA, and notices were issued. And for that sort of now has been filed. Why the sister was made party? It's the partitions, so plus the
Share was given to the sister.
what share was given. That's right. So you are appearing for the sister.
No, I am appearing for the respondent number 1.
Who has entered appearance on behalf of the sister? Rajesh Kumar's name is appearing.
Rajesh.
Where is he? Record happens.
Yes.
She was added as a party and then notice was issued.
Yes.
Or
We have filed ID. Yes.
you filed IA,
Yes.
but before adding her as party, we issued notice to her. Was she added as a party?
IA was filed for addition.
IA was filed for addition.
Yes, we have filed ID.
But I don't think that IA has been allowed so far. Where is Mr. Rajesh? IA pending है?
Yes.
IA अभी सुन के allow करना था इसलिए. बिना सुने कैसे किसी को पार्टी बनाना? But he is not there. FA number 132 of 2023. The learned counsel for the applicant Samasa. IA was filed for addition of party. The notice was issued and Wakalatnama has already been filed. However, nobody is appearing on behalf of the proposed respondent number 3. Respondent number 2. Close this case day after tomorrow.
लेकिन जो आइए मान लो इसका वकालत नाम फाइल होगी इसमें सरनेम में थोड़ा सा डिफरेंस आइए में मेंशन है वकालत नाम फाइल होगी
आइए और वकालतनामा का सरनेम में डिफरेंस.
आइए में जो पार्टी का नाम उसको ऐड करना
Madam, there is a difference between the wakalatnama and this. Geeta Devi, right? Spelling G-W-E-T-A. Her surname does not tell. Surname does not tell.
Then means we
Geeta Rajwar लिखा हुआ है.
in the Wakalatnama. Then IA I will have to.
It has been pointed out by the office that the proposed respondent has filed wakalatnama in the name of Geeta Rajwar, son of Shashi Bhushan Rajwar. Wife of Shashi Bhushan Rajwar. But in the utility application, the name has been mentioned as Geeta Devi, G-E-T-A Devi, और इसमें है G-I-T-A रजवार. आप हैं इसमें? बताइए इतना लेजरली इतना टहलते हुए आइएगा तो कैसे होगा? आप कैसे ये वकालतनामा फाइल किए? गीता रजवार
वही नाम
नहीं, उसमें गीता देवी.
हाँ
Components, I was under the impression of this thing, so I don't know if maybe the correct name is that. Because
she's the sister, so I asked them, they told that they हम लोग वैसे ही बना देंगे। तो उसको clarify करके तो fresh IE file correct कर देंगे। शशि भूषण रजवार को लिखे हैं। It's very important. आपको कोई दिक्कत है पार्टी बनने में? A share has been given to you also. इसको अभी कर सकते हैं फिर, because you have said that wife of Shashi Bhushan Rajwar. Yes. Right. तो कर देते हैं. Next. Then you will file an affidavit to this. This correction can be done today, but hearing part was he has no objection. He has no objection. You will be simply acting as a party. But आपको objection है कोई? नहीं ठीक है.
शेयर तो दिया हुआ है।
Share तो दिया, आपको भी कोई objection नहीं होना चाहिए. नहीं ठीक है, मैं उसको ठीक है. फिर से लिखे. आइए नंबर 12835 of 25 has been filed for impleading Geeta Devi, wife of Shashi Bhushan Rajwar, who is a sister of the appellant as respondent in the present case. The case arises out of partition suit and a portion of the property has been allocated to the sister also. A wakalatnama has been filed on behalf of the sister describing herself as Geeta Rajwar, wife of Shashi Bhushan Rajwar. The learned counsel for the appellant has submitted that the sister has filed the wakalatnama and maybe after marriage her name was changed to Geeta Rajwar instead of Geeta Devi. Yeah. She submits that she may be permitted to carry out necessary correction in the interlocutory application by changing the name of the proposed party. The learned counsel for the respondents have no objection to the prayer mail. It is not in dispute that the sister's husband's name is Shashi Bhushan Rajwar. Counsel for the appellant is permitted. You do the necessary changes. G-I-T-A Rajwar. G-W-T-A. With the consent of the learned counsel for the parties, IA number 12835 of 2025 seeking to add the sister as respondent number 2 in the present case is hereby allowed. The learned counsel for the appellant is directed to make necessary changes in the cost title in red ink during the course of the day. Stop at detail. Then what do you say? You are here to only take share? Yes, I am asking you.
So far as merit is concerned, can you take out the list? Only I received voting.
A share has been given to you, right? If you would like to file any written statement, etc., तब तो आपको वापस भेजना पड़ेगा ट्रायल कोर्ट में। और अगर आपको कुछ नहीं फाइल करना, you are happy with whatever share has been given to you and you don't want to file a separate written statement, then under such circumstances we will decide the case on it. ठीक है? When do you want file? Next week. Post this case on next Monday. Record आ गया है ना sir?
Yes.
If you want it, you take it. You can take it in the pen drive. Scan copy of the records. और तो कोई आगे पेंडिंग नहीं है इसमें? For final disposal? It's like it's after 2 weeks plus. On 18 for final disposal. The newly added respondent should specifically indicate as to whether ऐसा करते हैं मैडम, इसको हम नेक्स्ट वीक रखते हैं 10th को. On that day you indicate. I'm not saying anything. You indicate whether you want to file any written statement etc. then we will remand the matter. यहाँ पे तो पहली बार written statement का permission आपको देंगे.
She was not a party there.
I
And
know.
both the brothers' case is that this is our self-purchased property. Therefore, the partition suit will not bring the sister in picture. Though she is entitled, she would have been.
But still the share has been given to
Yes.
her. That is why we are late then.
Yes.
तो ठीक है उसको हम लोग टेंथ को रखें एक बार. Yes, madam.
ठीक.
Pose this case on 10th. For final disposal, I am disposed to it. But if required, we'll give a date.
Item 6 WPL 6910/2023.
Sorry.
For filing IA petition invitation,
Are you for?
there are some changes in the name of the business company. That's what we got.
Why are you seeking time again and again?
Only one time, last time we did time, we were only one week time we did. That's why we don't. I've informed you.
The case was taken on 6th of July. And today is 3rd of August. I've given you almost 1 month, not 1 week.
Time of the survive of operation.
WPA number 6910 of 2020. By way of last indulgence, time till 24th August is granted to the petitioner to take steps in terms of order dated 6th of July 2026. Post on 25th.
Item 7 first appeal 68/2024.
The supplement.
Respondent number 4 और 11 का डेट पूरा है. नोटिस वर्क इन्होंने इंफॉर्मेशन हमको दिया. Respondent डेट हमको सब्सिट्यूशन फाइल करना है.
Respondent के advocate ने आपको कब
आइए
कब फाइल की?
आइए के 5/8/25
तो अबेट तो हो ही गया ना? FA number 68 of 2024. The learned counsel for the appellant. In the records of the case reveal that as per order dated 13/6/25, the responding number 4 and 11 have expired. The details of the legal years and successors of respondent number 4 and 11 was also provided to the learned counsel for the appellant, which is apparent from order dated 10/10/2025. But no steps have been taken for substitution. Apparently, the proceeding as against respondent number 4 and 11 has abated. Post on 10th of August. इसका रिकॉर्ड आ गया है?
नहीं, इसमें रिकॉर्ड नहीं.
रिकॉर्ड नहीं आया.
जी.
बाकी लोग appeal करते हैं institute?
Yes.
You are appealing for rest of them?
Yes, my lord. And the matter has already been decided. One of the matter, but my lord has decided.
Where is
Same
that?
matter.
Where is that? Where is that order?
Order, I will bring on 10th.
What have I done in that?
My lord has dismissed the appeal of the plan and enhanced the compensation of this government. Upheld the order. Order. Order.
ये order final हो गया कि Supreme Court गया?
सुप्रीम कोर्ट जाने की कोई इन्फॉर्मेशन हम लोग को अभी तक नहीं मिला है।
Information? आप जाएंगे तो Supreme Court का जाने का information आपको कहाँ से मिलेगा?
हम लोग तो लिखे हैं लेकिन कोई
वो ये 28A वाला है।
यस
आप सब्स्टिट्यूशन नहीं फाइल करे किए तो क्या ही होगा? आपका वैसे ही डिसमिस हो गया, ऐसे भी डिसमिस हो जाएगा। सब्स्टिट्यूशन फाइल करके क्या करेंगे? Counsel for the respondents has submitted that the case is fully covered by the judgment passed by this court in FA number 70 of 2024. It was decided on 17/7/2025. इसका records अलग है क्या? Same records.
सेम रिकॉर्ड
रिकॉर्ड अलग अलग होगा,
रिवार्ड अलग अलग
अलग अलग रिवार्ड। दो केस और है नीचे मैडम अभी इस काम में लगा हुआ।
Land acquisition case number 6 of 2000. और इसमें लिमिटेशन भी पेंडिंग है।
लिमिटेशन
लिमिटेशन में आपको क्या बोलना है?
लिमिटेशन में भी कंट्रोल करते हैं।
I number 2330 of 2025 has been filed for condemnation of delay of 618 days in filing this appeal. कहाँ है आपका आयु?
आईए नंबर 2330 I will not and the first
आयु नंबर
330
2330 of 2025.
680
आपका एक आध आईए रिजेक्ट भी किए हैं ना? कोई आईए रिजेक्ट किए हैं आपका? नहीं, इसमें भी डिले था।
हाँ उससे भी डिले था डिले से डिले था दैट वाज अलाउड
The learned counsel for the appellant has submitted that has referred to the interlocutory application seeking condemnation of delay and has submitted that under similar circumstances, delay in filing FA number 70 of 2024 was also condoned. The learned counsel for the respondent, who was also a counsel for the respondents in FA number 70 of 2024, does not dispute the reported submission. He has no serious objection so far as the condemnation of delay is concerned. After hearing the learned counsel for the parties and being satisfied with the cause shown, IA number 2330 of 25 seeking condemnation of delay in filing the appeal is hereby concluded. Admit call for the records from the concerned court. Pose this case for final disposal on August 24th. डेट किसका हुआ था?
4 and just 66 and 4.
4 का नाम बताइए.
संजू महतो.
संजू महतो और रंजीत महतो. रंजीत महतो ना?
I am 11. संजू महतो, रंजीत महतो. Yes, रंजीत.
From the records, it appears that respondent number 4, Sanju Mehto, son of Piyu Mehto, has expired, but his full brother Naresh Mehto is on record. It further appears that Ranjit Mehto, son of Rogan Mehto, who is respondent number 11, has expired, but his mother, namely Lakho Devi, wife of late Rogan Mehto, is respondent number 10 in the proceedings.
Item 8, First Appeal 71 of 2024.
इसका बताइए, इसमें भी कोई बन गया? इसमें आगे फाइल हुआ है for condonation of delay. How many days? 618 days. Same day, same number.
Yes.
आप इसमें सबकी तरफ से अपील कर रहे हैं?
जी.
The learned counsel for the parties are present. IE number 4179 of 25 has been filed seeking condonation of delay of 618 days. बाकी सब delay का same to same. Delay is condoned. You are for all the respondents.
Yes.
The respondents have already appeared by filing wakalatnama, admit, call for records from the concerned court. इसमें आ चुका है. The records have already been received. The counsel for the respondent has submitted that the case is going to be covered by the judgment passed by this court in first appeal number 70 of क्या 70 of 2024. Post this case tomorrow for final disposal. Covered case है ना?
Item 9, First Appeal 72 of 2024.
हम बताइए.
ये फाइल का था 7, 12 और 20 के लिए.
7,
12 और 20 respondent. ये नंबर 10493.
4825 को ही आप सुनिए. किसका डेथ हुआ था?
इसमें respondent number 7, namely Fuchan Mahto, alias Fuchan Mahto, 12 Musammat Balki, and 20 Sarju Mahto.
तो respondent number 7, 12
and 20.
and 20. The learned counsel for the parties are present. The records of the case reveal that IE number 10493 of 25 was filed by the affidavit dated 4/8/2025, indicating that respondent number 7, 12, and 20 have expired. And have expired. The respondent number 7, namely Fuchan Mehto, died on 15/6/2016. The respondent number 12, namely Bulki, died on 31/7/2014. Respondent number 20, namely Sergio Mehto, died on 23/1/2025. The records reveal that the respondent number 7 and 12 have expired prior to filing of the present appeal. इसमें जजमेंट का डेट क्या है?
22 डेट है 23/12/2022.
However, the judgment has been passed on 23/12/2022. If a dead person के फेवर में हो गया तो क्या होगा? Yes.
2001-2 का था तो लोग सब्स्टिट्यूट है नहीं है करता.
आपने ना खुद को बताया कि मर गए हैं.
कोई
ये लोग कहाँ से
स्टेटमेंट
substitute करते? तो ये जजमेंट कैसे सस्टेन करें?
नॉलेज
The learned counsel for the parties are directed to address this court as to whether the impugned judgment would be a nullity in view of the fact that respondent number 7 and respondent number 12 had expired prior to passing of the judgment and they were not substituted before the court. Post nullity है तो जाएगा वापस, हम लोग क्या कर सकते हैं?
छोड़ के ये जो अवार्ड हुआ इस जो अपील फाइल हुआ है ये अदर्स जो है अदर्स को
ये अदर्स में तो सब हुआ है ड्यूरिंग द पेंडेंसी ऑफ द अपील, लेकिन इसमें हुआ है ड्यूरिंग द पेंडेंसी ऑफ द सूट, राइट? तो उसको तो नलिटी बोलना पड़ेगा ना, कैसे होगा? डेट पर्सन सबका बाइफोकेट किए हैं, एक ही साथ है, सबका सब एक ही फैमिली के हैं, कैसे अवार्ड किस तरह से बना है इसको थोड़ा देखना पड़ेगा ना, ऐसे नहीं हो सकता नलिटी ऐसे बोलने से.
इसको 2 वीक्स का टाइम दिया.
2 वीक्स क्यों चाहिए आपको?
वहां का रिकॉर्ड हम दिखवा लेते हैं कि वेदर दे हैव
क्यों देखवाना? रिकॉर्ड तो सब आया हुआ है. और अगर अवार्ड बना हुआ है, अवार्ड में सब्स्टिट्यूटेड नहीं है लोग, तो फिर कैसे हो? इसका रिकॉर्ड आया है?
यस.
दिखाइए सर, आप इसको देख लीजिए. नलिटी है तो कल इसको एड्रेस कर दीजिए, और नलिटी नहीं है अगर वहाँ सब्स्टिट्यूट हुआ है तो वी विल सी व्हाट इज टू बी डन. ठीक है, नलिटी है तो इट शुड नॉट सस्टेन ना.
इससे पहले वाला इसमें
नहीं, ऐसा कुछ तो आपका कुछ ऐसा पिटीशन भी नहीं है, आपने कुछ लिखा भी नहीं है. इफ इट इज अ नलिटी, इट इज अ नलिटी. इसके लिए हम लोग रिकॉर्ड नहीं हमारे पास. इसको कल रखते हैं.
हेडिंग से
क्या फाइनल डिस्पोजल?
प्लीज सब ऑर्डर
ऑर्डर सप्लीमेंट्री बता दीजिए, क्योंकि आई हैव ऑलरेडी सेड दैट दे विल एड्रेस वेदर इट इज अ नलिटी इन द
ऑर्डर्स में
2 चीज आपको देखना पड़ेगा. एक तो whether the parties are sufficiently represented, कोई उसका भाई बहन भी रिकॉर्ड में है क्या, उससे भी हो जाता है। और लगता है कि एक का नहीं,
इसको एक सप्ताह के बाद क्योंकि हम थोड़ा इन्फॉर्म कर लेते हैं क्लाइंट को, बैठ के क्लियर हो जाता
अच्छा
है।
ठीक है, पोस्ट इस केस ऑन नेक्स्ट ट्यूसडे
जी
इन द सप्लीमेंट्री कॉस्ट लिस्ट।
अब लाइक
Item 10, first appeal 110 of 2024.
this case, during pendency of this appeal, respondent number 2 died, and which her heirs and representative are already party in appeal as respondent number 9.
हाँ बताइए, आपको कुछ ऑब्जेक्शन? I number 1705 of 26. The learned counsel for the appellant has submitted that during the pendency of this appeal, the respondent number 2 has expired, leaving behind one daughter, namely Shushila Mehto, who is already a party as sole appellant in the instant appeal, and one son, namely Premchand Mehto, who is also a party in this appeal as respondent number 9. He submits that he may be permitted to delete the name of respondent number 2 from the cost title. The death certificate has been placed on record. The learned counsel for the respondents have no objection to the claim made. In view of their quoted submissions, IA number 1705 of 2026 is hereby allowed. The learned counsel for the respondent number for the appellant is directed to delete the name of respondent number 2 from the cost title in writing during the course of the case. आगे बताइए इसमें क्या?
Second IA है for restraining the respondent from creating
फर्स्ट
a
अपील एडमिट हो गया है, एडमिट तो हो चुका है, रिकॉर्ड आ गया है, क्या मैटर है ये बताइए?
टाइटल पार्टीशन है, पार्टीशन क्लेम कर रही है डॉक्टर 1/9 शेयर इन सूट
तो
प्रॉपर्टी।
आपको क्या परेशानी है इसमें?
इसमें कुछ प्रॉपर्टी बेच रजिस्टर तो होगा नहीं है प्रॉपर्टी, ये सिर्फ एग्रीमेंट से बेचते जा रहे हैं, तो उनको शेयर इसमें मिलेगा नहीं, फाइनल होगा
नहीं, आई डोंट गेट इट। एग्रीमेंट से बेचते हैं, एग्रीमेंट से कोई ट्रांसफर होता है?
और 46 का इसमें है सीएमटी एक्ट से ये प्रॉपर्टी होते तो परमिशन लेके इनको सेल करना होगा, परमिशन लेके कर नहीं रहा है, एग्रीमेंट पे ट्रांसफर करते जा रहे हैं।
नहीं तो
दिस में भी फाइनली डिसाइडेड
नहीं, आप चाहते क्या है इसमें? आप पार्टीशन सूट है ना,
Yes,
हमारी
ma'am.
पार्टीशन सूट में सिर्फ शेयर डिसाइड,
शेयर, यस
ठीक है?
यस
तो शेयर डिसाइड हो गया है, इसमें क्या दिक्कत है?
शेयर मेरा शेयर प्रॉपर नहीं मिला है।
क्या परेशानी है बताइए? Who are you?
यस आई एम daughter of the
तो कितना मिला है?
recorded tenant.
According to you, what should have been your share? You belong to which community? Community specified नहीं है तो हिंदू ही ट्रीट करेंगे।
हाँ, हिंदू
लॉ से गवर्न होगा। तो आपको क्या परेशानी है इसमें बताइए?
इसमें पूरा सूट भी डिसमिस कर दिया है, ये बोलते हुए कि इसमें अर्लियर ये सूट डिसाइड हो चुका है till this honorable court below.
हाँ, partition suit was earlier decided.
No, there was one title suit in which Tata still has filed a second appeal before this honorable court against Parvati Devi, that is my adverse position के आधार पे, and it has suit property has been given. I may permitted to read the judgment of passed by this honorable court.
Yes.
Moreover, here the question of relief in favor of defendant does not come in from the nature of suit. It was to be found out whether the plaintiff had come up within 12 so note for declaration of his title coupled with possession. If the plaintiff had so the automatically it adversary affect the plaintiff right and goes in favor of defendant. Moreover, the actual aspect when both the courts below had concurrent in finding of fact, then there is little scope to enter into. The actual question is evidence produced by the party in view of no find any error of law permitted.
So the entire property was decided in favor of somebody else.
It was decided in absence of state of Bihar earlier. Tata Steel and some private parties.
You were also party.
Yes, Lord, we were party.
Whose
Then-
adverse possession was declared?
Yes, Lord, in my favor, in our favor.
Okay.
Thereafter, we have preferred a title suit.
If the
Partition
adverse
suit
possession was declared in your favor.
in my favor, yes.
Okay, thereafter you preferred a partition suit.
Partition suit.
So that partition suit has been declined.
Yes, Lord, on the basis that the state of Bihar was not made party in
How are they
earlier.
concerned?
This is the illegality.
How the parties are concerned in a private dispute as to whether the state of Bihar is a
State of
party?
Bihar is the lessee milord who has given lease to the Tata Steel. So the state of Bihar and party belongs to competitive under 46. So state of Bihar is necessary party. So the learned trial court has ignored and dismissed my application, stating that earlier.
So there is some defect in party position and primarily there is certain defect in connection with party position.
Yes, Lord. In earlier proceeding, though we have raised the objection, we were defended. We have raised the objection.
But it has to be attained finality.
Yes, Lord. We have raised the objection that the state of Bihar is necessary party, so he may be included as party. But the Tata Steel has not included him, Lord. So we have the decision has come in our favor till this honorable court.
That you are in
Even-
adverse possession.
Yes, Lord. And then we have claimed partition, then trial court has dismissed. Okay.
Now the state of Jharkhand is also a party in these proceedings.
Yes, Lord.
State of Jharkhand has filed any written statement?
Then statement.
ये छोटा छोटा चीज पूछ
हाँ,
रहे हैं
नहीं,
जिससे थोड़ा सा समझ
Yes,
आएगा
yes,
कि
Lord,
क्या
yes,
केस
yes.
है आप
इसको किसी दिन फाइनल का
नहीं फाइनल आज
15 मिनट का
थोड़ा सा हमको समझ
जी, जी, जी।
ये स्टेट ऑफ
जी।
झारखंड डिड दे फाइल एनी ऑब्जेक्शन
Yes, उसमें था क्या था ऑर्डर्स में था हमने पूरा
नहीं आई कैन
Yes,
अंडरस्टैंड
yes, Lord, yes.
दे हैव नॉट फाइल्ड एनी रिटन
वादी का संक्षिप्त सर प्रतिवादी संख्या 3 का लिखित
3 का लिखे
प्रतिवादी संख्या
4 5 का है
ये है झारखंड सरकार है 11
11 में तो किसी ने कोई फाइल नहीं किया
हाँ इसमें नहीं है
इन्होंने कुछ फाइल ही नहीं किया झारखंड सरकार का कोई ऑब्जेक्शन ही नहीं है
तरफ से किए गए प्रति परीक्षण में ये प्रति परिस्थित किए हैं क्रॉस किए हैं
क्रॉस करके क्या होगा जब डब्ल्यूएससी नहीं फाइल किए तो ये सब क्रॉस का क्या लेना देना
and OP has sought to the state of Jharkhand but their council is also not present and both are he also wants to support
I'm supporting the case of
yes
respondent number 4.
only fighting against the state and Tata Steel.
and who is for Tata Steel they are absent has anybody entered appearance
Earlier he has
notice has been served Tata Steel also did not file any written statement
Tata Steel has lost his case.
जबरदस्ती का केस लड़ रहे हैं You are for respondent number 4 and
4 in
what about other respondents? Six to nine is an
only
immediate
Mr.
claim.
Dilip Kumar Karmakar lordship filed the Vokalatnam on behalf of the respondent number 4 and 5.
Okay, what about 6 to 9? Their appearance is complete.
These are 24 minutes on every respondent.
as per the office note, the respondent number 1, 2 and 8 have been served through their respondent number 1, 2, 8, 3, 6, 7 and 9 have been served either personally or through their close family members. Notice upon them is accepted as validly served. So far as respondent service note, service report of respondent number 10 and 11 is concerned, the same is said to have been served through competent staff. The notice upon respondent number 10 and 11 is also accepted as validly served. Respondent number 4 and 5 has entered a clearance by filing for palletnama. रिकॉर्ड भी आ ही गया है. During the course of, while going through the records, it appears that respondent number, the case, the written statement was filed by respondent number 3, 4 and 5 and 3, 4 and 5 only. The proceeding was ex parte against defendant number 1, 2, 7 and 9 by order dated 16/12/2022. It was set ex parte against defendant number 6 and 8 by order dated 23/8/2023. The defendant number 10 and 11 had appeared, but they did not file any written statement. Okay, अब बताइए कब करना है?
अगला सप्ताह
Oppose this case for at the request of the counsel for the parties who are appearing before this court. Oppose this case for final disposal on next Wednesday in the supplement. Parties to prepare short notes and submit it by Monday.
Yes.
Item 11, first appeal 82 of 2025.
Yes, Mr. Sharma.
Yes. In this case, we got a notification was issued and we got it has come that the respondent number 45 dead. And
Who is dead?
it's 45.
45. You are filing
I
subsequent.
have filed the application for deletion of his name and because the legal errors are on record as 46 to 50.
46 to 51.
And one more deletion is required, respondent number 15. He also died issueless. For that, there is already there. And some
Respondent number 15 has that.
died issueless.
You have filed your he died issueless. From
He
where do
died-
I get this? From where do I get that he died issueless?
He is from my client.
Sorry?
From my client. He is the
Okay, but you
respondent.
have to find your affidavit.
Affidavit has been filed.
Affidavit has been filed
Yes,
that he
that-
died issueless and for deletion of his name.
Yes, there are two persons I am saying.
Okay.
That is IA number 9462
9462 of
2026.
any objection, respondent?
So, in this substitution petition, they have substituted respondent number 24. who died in
24.
2014.
Yes,
more than
I'm
5 years.
coming. I'm
On
coming.
the same petition, they
In the same petition,
Yes,
24 is also
they-
there.
Deletion also, the command petition.
Okay, so these are 45 and 15 we are seeking deletion.
Finish. So far, there is
24.
24, 25, 29 and 60.
5, 29 and 60.
24, 25, 29 and 60.
When did they die?
Yes. One mother, my friend rightly, mother, learned friend rightly pointed out, he died way back in 2014 itself. And mother, another one mother, he died during dependency, that is 18th of March 2026.
25.
26.
Respondent number 25 died when?
18th of March 2026.
18/3/26. And 29
29
died
died mother in September 2020.
September 24.
Yes.
And
mother
60,
60 died on 25th of September 2025.
25, 9, 25. Prior to filing of this case?
Your Lordship, 29.
No, it has been filed on 6/8/24. Right? So
These three are
29
related.
filed during died during pendency.
Yeah, all these three are-
60 died during pendency and 25 also died during pendency.
Yes.
But 24 died
Prior.
much prior.
Right.
Did
But-
he contest the suit?
Madam, no.
He did not contest
No,
the suit.
Madam, there are several respondents. This is a partition suit.
That's right. Did he contest the suit?
No,
Any share allocated to respondent number
the suit
24?
has been dismissed.
Suit has been dismissed. Okay.
I have mentioned his legal heirs in the name of Madam.
His legal heirs are already on record.
No, they have to be brought on record. That's why I have invoked section 151.
No, if you see, if in a suit for partition, if one of the defendants died,
But
then
suit
what
will
will
not
happen?
abate. Suit will not abate.
No, entire suit will
Will
not
not.
abate. But the point is that does the judgment become a nullity?
No, my lord judgment is there and there are several other judgments.
My judgment is
Yeah.
primarily saying that if they are already represented by other respondents.
Yeah, they are represented.
No, respondent number 24 is represented by whom?
Yes, let us see, my lord.
Let us see respondent number 24. What is the name of respondent
Yeah,
number
I'm just-
24?
It is Anurul Bhak. Anurul Bhak. His brothers are on record. 25, 26, 27, 28. Let Yusuf Ali.
Just a moment. In the genealogical table, his name is not there.
No, I am reading from the memo of appeal.
Yes, but I am reading from the genealogical table at schedule 1. At page number 37.
Page 27.
37. Internal page 9. Have you got that?
Yes.
His name is not there. Name of Yusuf Ali is also not there.
They have been
Plaintiffs and the defendant's second party.
I will have to verify. They have been, might have been substituted later on. Because Vida Khatun is there.
No, there are two set of defendants. Defendant's first party and defendant's second party. Right? And defendant's third party is also there.
Yes.
Maybe some sale deeds are executed.
Yes. But his name is in the decree.
Maybe his name is in the decree, but before we say that he is already represented, defendant first party Anarul Haq, son of late Yusuf Ali.
My lord, may kindly see page 31 of the
Yes, I am at page number 31. Anirul Haq is
Bibi Najmul Nisha.
25. Just a moment.
She died and they were substituted.
Sorry, this 20, respondent number 25. What is the name of this respondent number 25?
25, my lord, is around 24.
Yes, or respondent
Your Lordship,
Anirul Haq.
just for a
Right,
moment.
yes, Anirul Haq.
Just for a moment, my lord. Page C, kindly see, my lord, page 31.
Yes, I am there.
Yes, Lordship, may kindly see Bibi Najmul Nisha, wife
Yes.
of MD.
Yes.
She died, my lord,
She
and
died.
was substituted.
And therefore, all of them are
Yes, they have all
So
come.
they are already on record. Their interest is represented.
Yes, yes, that's what I am saying. But he died, my lord, the person Anurul Haq, he died, my lord, 2014.
That's right. But his interest is fully represented
Represented.
by other legal years on record. Correct? Yes, what do you say?
Yes. My lord, judgment is there.
पता नहीं है कौन सा जजमेंट अब क्या है ना कि सेकेंड अपील फर्स्ट अपील का जजमेंट बहुत जल्दी से रिलाई नहीं करते जब तक सुप्रीम कोर्ट से अपहोल्ड नहीं हो जाए
And name of Bibi Nazmul Nisha is already there in the schedule.
Yes.
There is another judgment, Your Lordship, of Supreme Court.
ये जजमेंट अपहोल्ड हो गया
हम तो आज डाउनलोड किए हैं।
ये जजमेंट अपहोल्ड हो गया
हाँ, डाउनलोडेड है।
नहीं अपहोल्ड हुआ
अपहोल्ड, अच्छा।
देखिए तो सेकेंड अपील 304 of 2019
But my lord has taken into consideration the judgment which is being relied on, that how it can, when and how when it can be related. That judgment for
Yes,
2005 judgment, those aspects Your Lordship has taken into
so
consideration.
therefore his interest is sufficiently
Yes,
represented
sufficiently.
and rest of them have died during the pendency of this
They can be substituted.
They
And
can
he
be
can be, they, his legal years can be added, right, and under section 1.
तो उनके लीगल इयर्स को ऐड करने के लिए
आपका वो तो लाइन पिटीशन में लिखा हुआ है पारे
एक ही आईए में है सर
हाँ
एक ही आईए में है अब आप खिचड़ी बना देते हैं सबका
नहीं तो इसमें इतना लंबा चौड़ा ये सब शुरू कर दो कितना पिटीशन
आईए नंबर लोग मरते जा रहे हैं तो क्या ही करिएगा
इस बार
आईए नंबर 9462 आप जरा ऑर्डर ध्यान से सुनिए आईए नंबर 9462 of 2026 The learned counsel for the appellant has submitted that the interlocutory application relates to respondent number 45 and 15 and also respondent number 24, 25, 29 and 60. So far as respondent number 45 is concerned, their legal years are already on record who are respondent number 46 to 51. With respect to respondent number 15, the learned counsel submits that he has died issueless and therefore the learned counsel submits that it would be sufficient if respondent number 45 and respondent number 15 are permitted to be deleted from the cause title. With respect to respondent number 24, 25, 29 and 60, the learned counsel submits that respondent number 24 expired prior to passing of the improved judgment in the year 2014. And so far as respondent number 25, 29, 60 are concerned, they have expired during the pendency of the present appeal on 18/3/26, September 24 and 25/9/2025 respectively. He submits that the legal years of respondent number 24 are sought to be added in the present proceeding. The learned counsel has further referred to page number 31 and the internal page 3 of the impugned judgment and has submitted that earlier Bibi Nazmun Nisha, wife of Muhammad Yusuf, was the party, and upon her death, she was substituted, and one of the substituted legal year was son of Yusuf Ali, namely Anwarul Haq, who is respondent number 24 in the present case and has expired. The learned counsel submits that the estate of Bibi Nazmoon Nisha is represented by the other legal heirs already on record. However, he submits that through the interlocutory application, the legal heirs of respondent number 24 are sought to be added as party. Their details have been mentioned in paragraph 8 of the interlocutory application. The legal heirs and successors of respondent number 25, 29 and 60 have been mentioned in paragraph number
9, 10, 11, 9, 10, 11.
9, 10 and 11 of the interlocutory application is stated. The learned counsel for the respondents has no objection so far as deletion of the name of respondent number 45 and respondent number 15 are concerned. Accordingly, the counsel for the appellant is directed to delete the name of respondent number 45 and 15 from the cause title. So far as respondent number 24 is concerned, it is not in dispute that respondent number 24 was just one of the legal heirs of Bibi Nazmoon Nisha, who was substituted along with other persons. And therefore, it is not in dispute that her estate was duly represented by the other legal heirs who were brought on record before the learned trial court itself. इनको notice करना पड़ेगा सब. Let notice be issued to the persons who are sought to be added.
I have also filed an interlocutory application to condone the delay. So that
Separate IA.
That has to be condoned.
Another IA being IA number
9466.
9466 has been filed seeking condonation of delay in filing the petition for substitution. Let notice be issued to the legal heirs and successors of respondent number 24, 25, 29 and 60, whose details have been mentioned in the interlocutory application, through speed post for which recusals be filed within a period of 10 days. कहाँ के हैं सब लोकल हैं?
नहीं सब साफ है.
कहाँ के?
साफ.
साइंस पे लोकल मतलब झारखंड. And also through the concerned police station. दोनों का requisite file. Close this case on 3rd of September. 3rd September तक नहीं हो पाएगा. 10th of September. Awaiting service report. Office to track speed post.
35 to 38 का address मेरे रहने के चलते नहीं. But 39 is appeal.
39.
39 is appeal. तो इनको कहा जा सकता है कि नहीं.
35 to.
आज हम देखें आप इसमें आया है वो नंबर.
No, I appear only in 5, 6, 7, 8, 9, 10 and
39 wanted is appeared to go.
Who is 39? Who is appearing for 39? Who is respondent number 39?
39 39 is Firoza
Khan.
and others are not legal heirs of Musmat Hamida Khan.
Hamida Khatun.
Hamida Khatun, she is also daughter. Others are daughter and one is son.
आप 39 की तरफ से हैं?
No, Milo. I am for 1, 2, 3, 12, 14 and 16.
Who is for 39? Who has appeared for 39? Who has appeared for 39? आप लोगों को नहीं पता आपके पास किसका वकालत नामा है?
मेरा 5 to 11.
5 to 11.
58 to 63 except 60, no 68.
And who is for 39? Somebody has entered appearance. देखिए जरा लिस्ट पे किसका नाम है?
Mr. Ramchandra Sahu, Santosh Kumar Jha,
Mr. Ramchandra Sahu, Santosh Kumar Jha,
Mahavi Prasad Sinha, Vaibhav Gale.
as per the office note, respondent number 35 to 38 could not be found at the given address. The learned counsel for the appellant prays for some time to take appropriate steps for service of notice upon respondent number 35 to 38 at their present and correct address, or to file an appropriate petition seeking substituted service of notice. If the notices are filed at present and correct address, the same be kept on record so that appropriate order will be passed on the next date. ठीक है? आप उसका भी कर दीजिए। और तो कोई नहीं बचा?
एक तो ये है और इसमें एक डिफेक्ट लगा था, इसलिए आप चाहे तो सब्स्टिट्यूशन कीजिए या फिर इसको डिलीट कीजिए। हमने दो पिटीशन फाइल किए थे। एक पिटीशन हमने फाइल किया था कि नीचे में अपेयर नहीं थी, तो इनको हमें एग्जाम कर दें फॉर सब्स्टिट्यूशन। दैट इज आल्सो
ये 35 to 38
और दूसरा पिटीशन हम
सब्स्टिट्यूशन तो डिसीज तो नहीं है 35 to 38।
लेकिन माइलॉर्ड ने दोनों पिटीशन में नोटिस किया था, उसके बाद वो एक अपेयर किए हैं।
That's right, लेकिन देखिए जब तक सर्विस कंप्लीट नहीं होता है ना, वो ठीक नहीं है। आप सब्स्टिट्यूटेड सर्विस के लिए करेंगे तो पेपर पब्लिकेशन के थ्रू नहीं कर सकते हैं, ऐसे जजमेंट डिफेक्टिव हो जाए। ठीक है, वो लोग जीत जाएंगे तो उनको कोई ग्रीवेंस नहीं होगा, हार जाएंगे तो बहुत ज्यादा हो जाएगा ग्रीवेंस। We are just posting it on 10th of September. नोटिस उस दिन देखेंगे, आप अगर आइए फाइल कर दीजिएगा, चाहे नोटिस फाइल कर दीजिएगा तो उस दिन डिस्पैच उनकी सब शादी हो गई होगी ना, सब बेटियां हैं, इसीलिए they were not found.
Item 12, Civil Review 75 of 2026.
सिविल रिव्यू क्या चीज का सिविल रिव्यू फाइल करते हैं?
Because after judgment loss the prisoner has came and gives a document which shows that the plot is different.
नहीं ये आफ्टर जजमेंट कोई डॉक्यूमेंट ये सब हम नहीं सुनेंगे। क्या चीज का जजमेंट? सेकंड अपील का जजमेंट ना ना, ये सब हम नहीं सुनने वाले हैं। ये सब क्या है यार? फ्रिवलस लिटिगेशन क्या देखना है हमको? उसमें कुछ नहीं देखना। सेकंड अपील का स्टेज में आपको एडिशनल एविडेंस नहीं फाइल किया, रिव्यू में एडिशनल एविडेंस।
इसलिए फ्रॉड शुरू से फ्रॉड किया है।
कोई बात नहीं, फ्रॉड है तो आप एग्जीक्यूशन में यू हैव अ रेमेडी। एग्जीक्यूशन में देयर इज अ फ्रॉडुलेंट डिक्लेरेशन। नहीं ये सब फालतू चीजें मत किया कीजिए। आपको बिना सुन के ऑर्डर किए थे,
सुन के ऑर्डर
आपका क्लाइंट आपको लिटिगेशन आपको इंस्ट्रक्शन दिया होगा ना,
इन्फॉर्मेशन आया उसके बाद
इसका एसएलपी नहीं फाइल किए। गलत चीज मत बोलिए, आप लोग का एसएलपी फाइल आप क्या बोलते हैं?
24 डेट दे है इसको हम पारा फोन दिखा है।
नहीं आपको कुछ देखना ही नहीं है इसमें क्या डिफेक्ट है? ये तो मरने के बाद इंजेक्शन देने वाला काम है।
नहीं वैसा
बात है अभी आईसीयू में नहीं है, ये ऑलरेडी डेड है।
प्लॉट नंबर 5 to 4
नहीं वी विल
आप 4 to 4 को बोल के केस में है।
यू हैव रिमूव द डिफेक्ट्स।
हां डिफेक्ट रिमूव सारा डिफेक्ट ये दिया है
डिफेक्ट। तो ये लिस्ट कैसे हो? 3726 को टाइम टिल 3726 was granted to remove the defects. फिर all defects removed kindly register the case. उसके बाद फिर आया है डिफेक्ट नंबर सच एंड सच नॉट रिमूव। ये क्या चक्कर है? ये कैसे है? ये ऑल डिफेक्ट्स रिमूव करके रजिस्टर हो गया, उसके बाद में 19/12/25 का आ रहा है। हाउ इज इट पॉसिबल? नहीं वेरीफाई नहीं, बुलाइए आपने को, बुलाइए तुरंत बुलाइए। किसका काम है? आपका ऑलरेडी डिफेक्ट, आपका ऑलरेडी डीएफडी हो I will not entertain such a petition. Civil litigation ऐसे review आप फाइल करिए, आप इससे काम ही चालू करिए. सेकेंड अपनी कांस्टेबल से कब का सूट है?
सूट है 2008
2008
पार्टियां को मिला, लेकिन पार्टियां हमको ही मिला. नशे तो बैठ से माना गया. इन आपके जजमेंट लाया कि नहीं गरीब नहीं. वो भी जीरो ग्राउंड नंबर 6 शूट ही दिखा.
नहीं ये सब एरर हो जाए तो आपको सुप्रीम कोर्ट जाना पड़ेगा, हमारे यहाँ से नहीं. हम बहुत सोच समझ के ऑर्डर करते हैं सेकंड अपील और पूरा सुन के ऑर्डर करते हैं, इसीलिए ये कहानी हम
कोर्ट नंबर डिफरेंट आ रहा है या डिफरेंट आ रहा है, उसको लेके आप
इससे कोई फर्क नहीं. आई विल नॉट बॉदर अबाउट
तब हमने आरटीआई दी.
Item 13.
हमने आरटीआई दिया तब
आरटीआई में मिला, आरटीआई का कोई वैल्यू नहीं है. वी डोंट बॉदर अबाउट इट. प्लीज
यहाँ से वेरीफाई भी किया.
बहुत अच्छी बात, बहुत अच्छी बात है. अभी तो आपका डीएफडी हो चुका है, अभी इसको डीएफडी करते हैं.
Item 13 FA 303 of
आप ये देखिए
2026.
अभी आने वाला है. Yes, what is this? Limitation. कितना दिन का डिले है?
372 days का.
आप कौन है, सरकार?
नहीं. Payment sign for promotion of plan.
कितने केसेस एक साथ डिसाइड हुए?
58 cases.
बाकी सब केसेस कहाँ हैं?
55 फाइल किए हैं तो कुछ
कहाँ है, लिस्ट दीजिए.
कुछ में नंबर पड़ा है.
कोई बात नहीं, लिस्ट दीजिए, कल लेके आइए लिस्ट. Counsel for the appellant submits that out of the impugned judgment, 55 cases have been filed. 55 cases have been filed. He undertakes to provide the list of the cases tomorrow, post tomorrow. सब एक साथ टैग करके आपका जहाँ जहाँ डिफेक्ट रिमूव करने का एक साथ ऑर्डर, एक ही साथ. सबका कॉमन एविडेंस है, अलग अलग एविडेंस
नहीं कॉमन
है तो रिकॉर्ड कर.
Item 14.
सरकार है अदर सही
अदर सेक्शन.
नोटिस सर्व किए सरकार को, उनका नाम अपीयर कर रहा है.
सब
दे आर नॉट हियर टुडे.
तो
काउंटर भी फाइल करते हैं. डिले कन्वर्सेशन को अपोज करते हुए,
नहीं
सपोर्ट करते हुए. चलिए.
Item 14 First Appeal 315 of 2026.
Yes.
delay of 281 days.
Delay of
281 days.
281 days. Who are you?
CCL.
CCL को स्पेशल लॉ बनाया क्या CCL के लिए? हाँ? This is under old act or new act? This is under which act? Section 18.
Old act.
It is covered by some case?
No.
Yes, yes. Flat rate 4,800 enhanced work. It is covered by some case. 68 का 4,800 is a very familiar figure. क्या ग्राउंड है आपका? There is enormous delay. हम ऐसे डिले नहीं कंट्रोल करेंगे. बताइए, what is your ground? IA number 6239 of 26 has been filed. for convocation on delay in filing the appeal. You have served upon the state whose name is appearing. He is still a counsel for the state. The learned counsel for the appellant has submitted that respondent number 4 is to be represented by the office of learned advocate general, and copy has already been served. And the name of the counsel is also appearing in the cause list. So far as respondent number 1, 2, and 3 are concerned, notice may be issued upon them. Let notice be issued upon the respondent number 1 to 3 in IA number 6239 of 2026, and also in the main appeal, for which recusals we filed through speed post. And also through the concerned police station within a period of 1 week from today. Let the records be called for from the concerned court. It is made clear that the question of taking up the case on merit would arise only if the delay in filing the appeal is एक साथ कर देना ना, नहीं तो 6 महीना तक डेट ही पड़ते रहे. Pose this case on 3rd of September, awaiting service. Office to tax post delivery and prepare appropriate office note with respect to service of office.
Under heading for press filing, item 15 WPL 775 of 2026.
In this case, my lord, this is a remedy department. Dismissing the application number 6728 of the invasive disturbing without properly considering the case of the petitioner and without appropriate giving opportunity to the petitioner and the.
No, I don't get it. 2A2, it is an order of dismissal.
Yeah.
So you directly move the labor court.
Labor.
Okay. So what happened before the labor court? Where is the award? Award is.
Award is my page. Page 25. मेरे अगेंस्ट मिसकंडक्ट का एलिगेशन लगाया गया है, मेरे द्वारा कोई भी ग्रेटिफिकेशन नहीं दिया, बोला इनकी पत्नी के द्वारा ग्रेटिफिकेशन दिया, मेरे घर पर जाकर के फोटोग्राफ्स वगैरह लिए.
Award का कॉपी भी देती
और अवार्ड का
पेज नंबर
25 में एनेक्सर 1 में
आपकी पत्नी एग्जामिन हुई है कोर्ट में?
नहीं, पत्नी एग्जामिन नहीं हुई, फोटो एग्जामिन को प्रॉपर अपॉर्चुनिटी भी नहीं दिया गया क्रॉस एग्जामिन करने के.
किसको क्रॉस एग्जामिन करना?
जो गवाही गुजारे.
आपका डोमेस्टिक इंक्वायरी हुआ?
डोमेस्टिक इंक्वायरी.
डोमेस्टिक इंक्वायरी वाज फेयर और अनफेयर?
अनफेयर.
कौन सा ऑर्डर?
और हम
Where is the order by which the domestic inquiry was held to be unfair?
लेक्चर 5 जो है ना,
Annexure 5
लेक्चर 5 की इंक्वायरी हुआ मतलब ये
Annexure
लास्ट
5
में ये
पेज नंबर
पेज 63 मतलब हमारे इंक्वायरी पेज 63 मतलब रनिंग पेज 63 यही इंक्वायरी को?
हम इंक्वायरी रिपोर्ट की बात ही नहीं कर रहे. Before the learned labor court,
हाँ.
was the inquiry held to be fair and proper?
No, ma'am.
No, yes. कहाँ से बोल रहे हैं? It is just inquiry report. I just want to know before the labor court, the inquiry was held to be fair and proper or not?
Not, ma'am. Can you see in Excel 8 ma'am? सब हर एक जगह एप्लीकेशन देते गए.
आप मेरा बात समझ ले रहे हैं कि समझना चाहते नहीं?
नहीं, जो कहेंगे
है ना. पहले लेबर कोर्ट में क्या डिसाइड होता है, डोमेस्टिक इंक्वायरी हुआ कि नहीं हुआ, and whether the domestic inquiry was fair and proper. That is the first thing which is decided before the labor court. In case of dismissal या इस तरह का कोई भी मैटर आता है.
देख लेते हैं नेक्स्ट मंडे को.
Notice has have to be sent in this Tata notice.
अभी तो हम नोटिस के मूड में ही नहीं है. अब जबरदस्ती आपको नोटिस कर दें.
नहीं Tata notice करना है for the state.
अभी तो prima facie, if I am not satisfied, I will not even issue notice. Why should I issue notice?
Yes. By reading
I just wanted to know, is there any finding that the inquiry was held to be fair and proper?
page
or
28 paragraph
11A में ही तो हुआ है. Page
28 paragraph.
Furthermore, case of the workman inquiry officer did not even permit to workman to go through the management's exhibit produced in the inquiry. They did not give opportunity to workman to produce his document and also to produce his defense witnesses the inquiry. The inquiry officers also did not allow the workman to give his own statement and cross-examine all the management witnesses fairly and conducted the inquiry in the superficial manner with the her determination of holding the workman guilty of the charge level against him. The inquiry officer finally prepared their inquiry report, which was not based on material on record available in the inquiry proceeding, and they have submitted their inquiry report with the predetermination of providing the workman guilty of charge level against him.
That is only the submission.
और मैनेजमेंट को मैक्सिमम पनिशमेंट
पैरा 17 पढ़ी. पैरा 17 at internal page 14.
After having all done by the court with respect to the conduct of the domestic inquiry by the order dated 2/3/20, find and told that the PO that domestic inquiry proceeding against the workman to be fair, proper, and very fully in consonance with
There
the
was a specific order passed by the labor court that the domestic inquiry was fair and proper. That order is not under challenge in Europe. So now the domestic inquiry is fair and proper.
no letter has been issued to.
There is a specific order passed. What do you mean? That order is not under challenge.
Then I will.
No, I will not permit order.
Madam,
आप बिना पढ़े, बिना इम्प्यून ऑर्डर पढ़े, आपको पता ही नहीं है. आपने जब ये बनाया तो वो इम्प्यून ऑर्डर बिना पढ़ के बना दिया. I will not permit order. No. कोई डिप्राइव तो आपके कारण से डिप्राइव हो ही जाएगा कोई भी आदमी. जिससे हम एक सवाल पूछ रहे हैं तो ये नहीं पता है कि डोमेस्टिक इंक्वायरी फेयर एंड प्रॉपर हुआ था कि नहीं हुआ. इम्प्यून ऑर्डर में दिख रहा है.
हम तो हर एक जगह लिखे कि फेयर और प्रॉपर नहीं हुआ है.
उससे क्या हुआ? There is a specific order drawn to that effect. That is order dated 2/3/2020. No, I just. No.
मैक्सिमम पनिशमेंट दे दिया. इनका मिनिमम पनिशमेंट भी देने का है.
आप रहेंगे तो इनको फांसी का सजा भी हो सकता है. जैसा आप केस कंडक्ट कर रहे हैं ना, इस तरह से आप केस कंडक्ट कर रहे हैं अपने लिटिगेंट का. आप भी बताइए. आपको नहीं पता है. You are not aware.
I'm sorry. Lenient view में का नहीं टेकन.
What lenient view should I take?
हम उसको चैलेंज करते हैं. इसमें चैलेंज कर हम तो पूरा लेबर कोड के ऑर्डर को चैलेंज किया।
इससे क्या?
लेबर कोड के ऑर्डर
There is a separate order passed whereby the inquiry was held.
हम जैसा उसको इंक्वायर कर लेते हैं, मतलब हमको नहीं
इंक्वायर कर देते हैं।
नहीं इसमें है लिखा हम नहीं मिला, इसलिए हम इंक्वायर करते हैं, अगर होगा तो उसको चैलेंज करते हैं, इसमें चैलेंज काइंडली।
I am your advisor.
नहीं नो
Then इम्प्यून ऑर्डर में लिखा हुआ है, आप बिना पढ़े केस फाइल करते हैं। नहीं नहीं, ये सब एकदम नहीं चलेगा। I will not tolerate all this. इतना
हम मानते मेरे कारण अगर मानते हमारे द्वारा कोई गलती हुआ उसे डिप्राइव कर दिया,
डिप्राइव का आपके कारण।
तो इसीलिए
एक बात बताइए, डॉक्टर गलत ऑपरेशन करेगा तो पेशेंट मरेगा ना? वो यहाँ है वकील साहब का।
मरने के पहले हुजूर को रिक्वेस्ट कर रहे हैं ना कि उसको थोड़ा सा और हम उसको कर देते हैं चैलेंजेस में इस एप्लीकेशन।
नहीं हम आपको ये सब नहीं करना,
चैलेंज कर देंगे उसको। हम तो उसको एग्जामिन भी करते हैं, फाइल भी करते हैं।
फाइल करने के पहले एग्जामिन करना चाहिए। What the learning council is reading on behalf of the petitioner. This petition has been filed challenging the award in order dated 8/3/2025 with the bracket annexure 1.
My prayer opportunity may kindly give me filing challenging the
प्रैक्टिस सब तो हो गया होगा, आपको प्रैक्टिस हो गया ना?
मैंने केवल बोली हमारी हम उसको
कोई नया लड़का हो तो बस
नहीं ठीक है, गलती हो गई,
करेंगे तो
अगर गलती हो गई हुजूर तो उसको क्या थोड़ा सा उसमें अगर हुजूर नहीं कर करने देंगे तो उसके लिए भी प्राय, इसलिए हमको 2 वीक्स टाइम दिया जाए उसके लिए।
Learning council for the notice be issued to respondent number 3, for which requisites under speed post be filed within a period of 1 week period. Let the records be called for from the concerned. Post this case on 14th of December of 1876. ऐसा गलती महेश जी को करना है, बताइए तो आप लेबर को मतलब दिवाली दीजिएगा।
मतलब हमारे कारण अगर वो डिप्राइव हो जाए, इसीलिए हुजूर से हम इतना।
आप ही बताइए, आपको एक ही सवाल पूछ रहे हैं, डोमेस्टिक इंक्वायरी बस फेयर एंड प्रॉपर, आप साइलेंट हैं। इसका मतलब आप इम्प्यून ऑर्डर बिना पढ़े बहस भी कर रहे हैं और इम्प्यून ऑर्डर बिना पढ़े ड्राफ्ट भी किए। Let us take it. It speaks volumes. किए हैं? क्या नाम है आपका?
गौरव प्रियदर्शन,
How many years of practice have you put in?
3.5 years.
सेक्शन से आया है एक्चुअली देखिए ये पोस्ट में लगा रहे हैं लास्ट में होना चाहिए लेटेस्ट नोटिस
जिस दिन हम ऑर्डर पास किए उसके बाद कोई भी डिफेक्ट नहीं पहुंचा।
उसके बाद डिफेक्ट रिमूव हुआ वो रजिस्ट्रेशन के लिए वो क्रोमोसोम में नहीं लगते ये फर्स्ट में लगा दिए और लास्ट में
नहीं एक सेकंड कहाँ है आप हैं इसमें?
ये रिमूव हो गया
इसमें कोई डिफेक्ट नहीं है?
नहीं ऊपर वाला नोट है सबसे ऊपर लास्ट ऑफिस नोट ऊपर
किस तरह का नोट बना है? यहाँ पे ऑर्डर्स में डिफेक्ट करके ऐसे लगा हुआ है। एडमिशन में किस हेडिंग में?
ये है ऑर्डर्स
ऑर्डर्स में क्यों? नहीं हम आपको बिना लिमिटेशन ऐसे नहीं आपको बिना लिमिटेशन भी आप पहले सेटिस्फाई करिए तब लिमिटेशन पे नोटिस करेंगे। आप यहाँ मैकेनिकली हम लिमिटेशन पे नोटिस नहीं
number 5 and 6 of the review.
This court has committed a mistake.
Yes,
What mistake? Leading से दिखाइए और एविडेंस से दिखाइए कि कोर्ट से गलती हुई। Evidence. Which paragraph?
Paragraph 16. Paragraph 16.
Paragraph 16 of the interim order.
Yes,
इसमें क्या गलती है? Paragraph 16 of the interim order बताइए। Paragraph 16 में क्या एरर? In favor of the plaintiff number 2.
Three plaintiff number 2 is not entitled to the trial court judgment.
Yeah.
That plaintiff is not entitled to get a share of his mother's estate. And the salary of the
he may not be entitled to a share, but if a person is relinquishing the share in favor of somebody, ये कहाँ से आ रहा है कि they have relinquished the share in favor of somebody? From where do I get this?
Because they have also purchased land from the some of the prisoners. उसी पाया कि वो salary is valid.
आपने देखिए, you just straight away, you say that this is an error of record. It's a mistake. Error of record भी नहीं बोल रहे हैं, बोलते हैं कोर्ट का गलती है। तो आप बताइए हमको गलती।
हम सेकंड में आ रहे हैं उसके बाद
अभी पैरा 16 में ही हम रुके हुए। Ground number जो है आपका, I am stuck there only. This that the plaintiff number 1, 3 and 4 had relinquished their share in favor of plaintiff number 2. ये correct है कि incorrect?
That is correct.
That is correct.
That is correct.
तो आपका जो ये ground आप हमको बताएं।
नहीं तो correct इसलिए नहीं है कि 43 बोला वो share है, आप बोलते share नहीं है।
I don't get it.
कि हम लोग प्लॉट पे जा रहे हैं कि अगर प्लॉट ही नहीं उनको मिला है और हम प्लॉट अगर ला के दे रहे हैं खतियान से कि उसका शेयर था 12 डिस्ट्रिक्ट और तो 130
देखिए आपने सीधा सीधी इस पे पैरा नंबर ग्राउंड्स में आइए, ग्राउंड्स किस पैराग्राफ में है? Ground number 6 and 7, ठीक है? I will look at this ground number 6 and 7. ये सब कहानी नहीं, आप जो दिखाए थे वही दिखाइए। If there is any fraud, fraud is to be pleaded.
I have pleaded.
You have proved it.
I can, now I want to prove.
You want to prove it.
Yes, because
After dismissal of second appeal, in a review petition, you want to prove the fraud. Is there any finding of the learned courts that there was fraud? Is there any finding of the learned courts? Fraud is a matter of fact. That fact has to be there in the finding of the learned court. Is there any finding of the learned court that there was a fraud? Then,
review there will be also permissible lawsuit on the fraud and suppression of visual evidence. We have got the visual evidence.
no, just a moment.
That's why we have only come.
No. You see, review if there is a suppression of fact, etc. But in second appeal, there is no question of suppression of fact. Second appeal, we formulate a question of law and then we decide it. If no question of law has been framed on fraud, we are not supposed to decide it. No, but no substantial question of law was framed on fraud.
No.
Then?
They framed lawsuit about a title of the predecision of Mohammed. Now I am come with the fraud. If the plaintiff having based on the fraud, if the plot is concerned, if this plot is said, in the first plaint, it has been said it is 4 plot not 4 to 4 area 130. Now from a record source, no, plot not 4 to 4 is only 20.
Petition नहीं पास कर.
हम ये कहा था रिव्यू करने का अगर फ्लॉट है
Review.
तो क्या हम तो दिला सकते डिसऑर्डर
नहीं अभी लिमिटेशन पे हम नोटिस नहीं करेंगे जब तक हमको सैटिस्फाइड नहीं होगी हम लिमिटेशन बाद में सोचेंगे
हम सैटिस्फाई करें
नहीं आप सैटिस्फाई करें
पारा 6 और 5 से
पहले आप ओरिजिनल दिखाइए टाइटल सूट का जजमेंट यस
दैट इज आल्सो नेक्स्ट
आप अपना रिटन सबमिशन पर हम नोटिस नहीं करेंगे ऐसे आई विल नॉट इशू नोटिस इसका सेकंड अपील का रिकॉर्ड है जो आया होगा ना ये जिसका ओरिजिनल रिकॉर्ड होगा सेकंड अपील का हमको वो चाहिए इसका इनका सारा इलिजिबल डॉक्यूमेंट्स हम निकाल सकते हैं आपका तो कोई प्रपोज सब्सटेंशियल क्वेश्चन ऑफ लॉ में फ्रॉड का जिक्र तक नहीं नहीं रिव्यू पर ही हम जा रहे हैं आपका जो प्रपोज सब्सटेंशियल क्वेश्चन ऑफ लॉ है वकील साहब है ना बनाए होंगे तो नया सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रॉड पे कैसे आप प्रपोज कर रहे हैं
हम फ्रॉड तो उस पे नहीं जाएगा अगर ट्रेड का कैसे और बैच से फ्रॉड है उसको अगर आप जान गए कि हम नॉलेज ना अगर डॉक्यूमेंट्स पे जा we have only on documents
डॉक्यूमेंट्स का तो सेकंड अपील में क्या डॉक्यूमेंट्स का रीएप्रिसिएशन नहीं हो सकता नॉट परमिसिबल
नहीं लेकिन सेकंड अपील रिव्यू हो सकता है हम कहते हैं फ्रॉड आता है बोलते हैं सब्सटेंशियल फैक्ट
आपका कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ था ही नहीं फ्रॉड का प्रपोज सब्सटेंशियल क्वेश्चन ऑफ लॉ में कोई फ्रॉड का जिक्र नहीं है
उसमें था तो देकर कि टाइटल है कि नहीं अगर प्रिसीजन का है तो ये आप तो रिव्यू देखेंगे ना कि अगर कहीं फ्रॉड तो कभी प्रिंट कर प्रूव कर
फ्रॉड इज अ वेरी स्ट्रांग वर्ड
very strong
I want to know where is the finding of the learned court on the point of fraud.
That is not finding on the.
There is not finding.
That is there. Finding is there that which fraud is involved in the suit. And we compare the plaintiff with the earlier plaintiff. If in both the plaintiff we have compared, then we find that
we are not here to compare all this.
So I to
in second appeal we are not supposed to compare all this.
We have to come to truth lordship. If there truth has come before the court or not by any in the review or any
ऐसा नहीं है लॉ रिव्यू का ठीक है ना
ये तो देखेगा ना कि हाँ there is fraud or this or some fact is there if the same not allotted to the plaintiff then he can claim
you are seeking review on the basis of certain information received under right to information
no
You have any certain documents?
Yes, we have received information that after judgment.
Why should I entertain that?
No,
Who stopped you? Just a moment. Who stopped you from taking any steps before the court for calling for the records or for examination?
other document is there, Satyan is there, Lordship of Party. It is Parson, so they have also put the say of my study is valid. Lordship has said, no, that your study is not valid. That is the conflict of time. That we have got the reason my
आपकी
study
बात
is
हमको
valid.
समझ नहीं आती. आप अपना आपकी बात हमको
No,
कभी
so
समझ
I
नहीं
find that
रिटन एग्रीमेंट में एक पूरा जजमेंट ट्रायल कोर्ट का प्लेन से लेकर सब चीज लिखी है. प्लेन में क्या लगा हुआ नहीं, आप रिटन एग्रीमेंट में बनाइए. आधा डॉक्यूमेंट तो पढ़ा ही नहीं रहा इसमें. आई एम नॉट एबल टू रीड इट. नहीं वो नहीं. आप अपना रिटन सबमिशन फाइल कीजिए. प्लेन में क्या केस था वहां से शुरू करिए. आप करिए. उसके बाद हम सोचेंगे कि मेरा कोई रिव्यू का केस आपका बनता है कि नहीं बनता. किस क्या इशू फ्रेम हुआ था, क्या फाइंडिंग हुआ था. ऐसे नोटिस तो हम नहीं करेंगे. 3 weeks है, 3 साल बाद कर सकते हैं उसमें.
नहीं after 3 weeks I can do it.
और एक भी टाइपिंग एरर नहीं रहना चाहिए.
नहीं कोई टाइपिंग नहीं.
Counsel for the petitioner seeks adjournment. Post on 11 December. 11 दिसंबर को आई. बहुत अच्छा दिन. ये मनाइए, इसी साल फिक्स हो गया सेकंड.
Item 16 WPL 795 of 2026.
Read petition. Who is for the petitioner? शिव कुमार सिंह, राजनंदन चैटर्जी. शिव कुमार सिंह का केस आप करते थे ना? आप यू यूज्ड टू डू. आप करते थे ना शिव कुमार सिंह का केस? नहीं, वो जो उनका नाम नहीं है. आप करते थे ना इससे सुना? शिव कुमार सिंह का केस.
एक केस में रिस्पोंडेंट थे. पासवर्ड के इन्फॉर्म करा.
He appears on behalf of the petitioner. Postman. उन्होंने कौन से दिन फिक्स किया था? थर्सडे को पोस्ट कर.
Item 17 WPL 1224 of 2026.
My lord, election 4 is under challengement, which is the order of the order of the Labor Court Cum Employees Compensation Commissioner Adani. What happened in this case, my lord?
Employees compensation.
Yes. What
You have filed a writ petition.
WPA, that is.
This under, if there is any assessment under employees compensation, it is an appealable order. How this writ is meant? It is an appealable order under section 30. Are you aware? Yes or no?
Yes, it can be appealed via the miscellaneous appeal.
Yes.
Anybody may be able to file this. इसमें एक ही ग्राउंड
The learned counsel for the parties are present. The learned counsel for the respondent has submitted that the interim order has been passed under section 22 of the Employees Compensation Act. The writ petition is not maintainable as the same is an appealable order under the provisions of the same Act. To this, the learned counsel for the petition submits that he may be permitted to convert this writ petition into an appeal. Considering the submissions, the petitioner is permitted to convert this writ petition into an appeal by filing appropriate interlocutory application. Upon filing of कब तक आप फाइल करेंगे? Just a minute. The learned counsel for the petitioner is permitted to convert this appeal into miscellaneous appeal. The needful to be done within a period of 1 month from today. Office is directed to renumber the case and undertake fresh stamp and post this case before appropriate bench as proposed.
Appearance is it. Item 18 WPL 1259 of 2026.
Under the unit of statutory acts, we are challenging the order passed by the appellate authority, that is the Judicial Court of Appeals. They admitted back his proof that in 2019 the employee expired and the son of the respondent hearing is still in the occupation of the company's quarter, and the appellate authority has not allowed us to deduct the gratuity amount, deduct the penal rent from the gratuity amount. Kindly see para 30 of my petition. Para 30. That the petitioner states that Mutera Hari, son of Gavin Hari, has not located the company's quarter period for which he has been served with eviction notice under PPI. It is further stated that 10/15/11/25 for a period exceeding 5 years, the penal rent has been calculated to serve. So still they are in occupation of the company's quarter, and the appellate authority has directed us to make payment of the gratuity amount along with interest.
This judgment of Raghvendra Singh.
Yes, 2000 recently in Calcutta High Court has passed very exhaustive order in April 2026 taking into account a number of judgments, more than 10 judgments have been considered, and it has been held that the employer is capable to deduct the penal rate.
On the basis of
The rules-
Mahanadi Courts.
No, Raghuveer Singh, Wazir Chand, etc.
So Wazir. There is a, let me just.
Raghuveer Singh has been considered at para 14.
Our High Court has also dealt with this Wazir and Raghuveer Singh. Where is that judgment?
This was the most recent one, Raghuveer Singh.
अपने High Court का judgment नहीं देखते.
He arises from this High Court itself.
इस High Court का orders कोलकाता High Court में चला गया.
Raghuveer Singh का
जजमेंट और ये वजीर का जजमेंट कंसीडर करते हुए हमारे हाई कोर्ट ने भी तो जजमेंट किया है, तो देखा है कि नहीं देखा है. तो अपने हाई कोर्ट का पता ही नहीं है, दूसरा हाई कोर्ट में भटक रहे. हम ही किए हैं जजमेंट, हमको याद है, लेकिन एलपीए में क्या हुआ है हमने क्या.
ठीक है.
I have no idea. Issue notice to the learned counsel for the petitioner has submitted that the point involved in this case is fully covered by the judgment pronounced by Honorable Kolkata High Court on 1/4/2026 in WPA number 6050 of 2026. However, the learned counsel has submitted that he shall make effort to find out the views of this court in with respect to the point as to whether the penal rate can be deducted from the gratuity payable. However, since a judgment of Honorable Kolkata High Court has been produced before this court, it is kept on record. Issue notice to the respondent for which requisite under speed post be filed within a period of 1 week. Post this case on 3rd September, awaiting service report, office to track speed post.
Only speed post.
Under heading for admission, item 20, item 19, WPL 1321 of 2026.
Yes, petitioner. There is a petitioner. This is under minimum wages. Where is the petitioner? Whom are you representing?
I'm appearing on behalf of Central University. Sorry, Central.
Central?
Union of India. Respondent number 1. Regional Labor Commissioner Central.
The order and the minimum wages, is it appealable? Right? Is it an appealable order?
Yes,
Petitioner cites his marks.
Counsel for the petitioner is absent. Counsel for the respondent is unable to. Under which section? Under which section?
Every direction of the authority under the section shall be final. Every authority appointed under the subsection shall have all the power as civil court under the Code of Civil Procedure 1988 code in purpose of taking evidence and enforcement attendance of the
अपील की बात पूछ रहे हैं आप, क्या बात प्रोसीजर की बात कर रहे हैं? Is it an appealable order like minimum?
Leadership, in my opinion, it's not available.
They are only agreed by certain computation in this case. So are we here to compute? There is no power of review, but by the order of the court, we can ask them if there is any computation error. They can point it out. What computation error they have pointed out?
They are stating in para 12 leadership that para 12 that the awarded compensation at twice the said amount.
Yes.
This is the computation error.
That is as per law. Compensation is twice the amount.
And overall, they are saying that they do not have the liability to make the payment. As they
Who has the liability according to them? They are the employees of whom?
NHI.
They are the employees of NHI.
Yes.
And who is the
not
petitioner
employees,
in
but
projects?
under the contract.
No. It is NG projects only who has to pay. They have entered into a contract with NHI for the execution of certain contract.
Yes.
But minimum wages has to be paid by the
Yes. That's
contractor
the
only.
petitioner's case that they are trying to say that we are not the proper employer. That's
No,
the
where
case
is
that
the
they are trying
contract?
to
Have they placed on record the contract with NHI?
No, lady.
Responsibility for payment of wages, page 67. You can have a look at that. Page 67, responsibility for payment of wages. It is with the contractor. The learned counsel for the petitioner is absent. No adjournment request has been circulated. Accordingly, this petition is dismissed for non-prosecution.
That's with heavy hearts, my lord, I am paying for commencement this. Lord,
Why at this 4:30?
Lord, the king is my lord, before my lord. She was called my lord in case, my lord, item number 536, my lord.
36. Which case? First half.
First half, my lord.
She did not appear.
She couldn't, my lord.
She couldn't, so what can I do about it? I must have passed an order.
She just
She is rustic lady and you are equally rustic. Once an order of bail or denying bail has been passed, how will I recall that order? That's true, then why are you mentioning it? You have some sense or you don't have any sense? किसी को bail दे दिए होंगे तो हम उसको recall कर लेंगे? Allow हो गया है? आपको क्या लगता है? कि जब मन होगा आप मेंशन करेंगे, आपको शर्म नहीं लग रहा है मेंशन करने में? Sorry, you say sorry to your litigant. उस समय आप आए नहीं थे, आपका litigant होगा और आपके absence में order हो गया. Okay? No what? She came means what? Who has she given you some wakalatnama? Are you holding wakalatnama on her behalf?
My lord, sir.
Did you file it?
Today, my lord, when she reached in the court, my lord came.
After the order?
After.
We don't bother about it. Bail order has been passed, ask her to get the accused convicted.